Good. All right. We're going to visit today for about 20, maybe 30 minutes, but probably closer to 20 minutes about ladybird deeds and transfer on death deeds. Just kind of want to tell you what they are, how they work, and what the difference between the two of them are. It's the purpose of today's webinar. So ladybird deeds and transfer on death deeds are a type of real estate deeds that transfer real property, meaning land or house or building, or oil and gas rights, mineral rights. But they don't transfer the property interest until the person who made the deed dies and passes away. It basically states, this is who gets my property when I die. These deeds are very important types of deeds that we use when a family member owns land or a house and is going into a nursing home and getting Medicaid to pay the nursing home. However, they can only request that to happen through a probate process. So we want to transfer land and houses outside the probate process, like a direct beneficiary designation does on financial accounts. And so we use one of these types of deeds to accomplish that. Now, we also use these deeds just everyday estate planning. So let's talk about some of the differences. You are called the grantor when you sign a deed. You are granting a right to somebody else. The person who's getting the interest that you're giving it to is called the grantee. So the grantor signs a deed transferring ownership, but when they sign a ladybird deed or transfer on death deed, which we'll call a TOD, T-O-D-D, TOD, a transfer on death deed, we retain the right as the grantor to still own the land and do whatever we want with it. We retain the right. So we can still sell the property, we can still mortgage the property, we can refinance the property. If we have a lot of land and we're getting oil and gas royalties, we still get to keep those. So we're the grantor and we're still the owner of the land because we're only giving an interest up on our death. So the grantee has no interest as long as I'm alive. They don't inherit it until I pass away. And this is not considered a gift because I retain control over this land and rights to do whatever I want with it until I die. So how does this affect our taxes? It does not affect our taxes. When we do a ladybird deed or a transfer on death deed, it should not at all affect any of our taxes because once again, it's still considered our property for all purposes. If we're over 65 and we have the extra 65 and over exemption, that shouldn't get changed. If we have any other exemptions, that should not change anything. Another thing to be aware of is capital gains taxes. If I inherit some land or a house or property from my mom or my dad when they die, I get what's called a step up in basis on the property. So the nice thing about these deeds is they are considered by the IRS and they allow us to still get the step up in basis. All right. Can you revoke a ladybird deed and a transfer on death deed? Yes, you can revoke either one of them. They're always revocable as long as the grantor is alive. All right. But it's important to note that I can't revoke it by saying in my will, I no longer want my house to go to somebody as stated in my ladybird deed or a transfer on death deed that I previously did. That will not revoke the ladybird deed or the transfer on death deed. It has to be in writing, signed by me, and it has to be filed at the county clerk's office in the same location where I filed the deed itself. Otherwise, it will not be revoked. Once the grantor dies, the person who signed the deed and makes the transfer on death deed or the ladybird deed, what happens? Well, there's an automatic vesting in the grantee of this property. So the grantee automatically owns it at that moment. What they should do is perhaps deliver a copy of the death certificate to the appraisal district. And we might often will do what's called an affidavit of death, where we file with the clerk's office an affidavit stating that a ladybird deed was done on this date and time. It was signed, it was recorded in this number at the county clerk's office. this person died on this date and time, and it vested in the grantee, being me perhaps, on this date when they died. When the house transfers on death, it takes with it any liens, any encumbrances, mortgages, deed of trust, anything that's been signed goes with the house, but it will avoid Medicaid estate recovery. When we apply for Medicaid, I kind of already touched on this earlier, we have to have one of these types of deeds in order to protect the house when we die and not have to sell it and pay Medicaid back. There's no current transfer, so there's no penalty for Medicaid purposes. There's no gift made to anybody because Medicaid still considers the property belonging to the grantor. And then when the grantor dies, there's no issues with the Medicaid estate recovery because, as we said, it's a direct transfer. Lady Bird deed is created through kind of case law, an old rule in the Texas Property Code, and it's actually officially called an enhanced life estate deed. Lady Bird deed is a nickname for an enhanced life estate deed. The TOD, transfer on death deed, is statutory. There is a specific statute that has specific requirements that must be followed and met. And if they're not strictly followed and they're not strictly met in the form of the deed, then it will not be a valid deed on death. And so, whereas a Lady Bird deed is more traditional, you use the same format and it meets the same requirements of a standard special warranty deed. You just have a reservation clause, and then you're gonna be more safe with that. So statutory requirements for a transfer on death deed. So it has to be signed by the grantor and it has to be notarized. All deeds have to have that. It has to be recorded during a grantor's lifetime. It has to, of course, be recorded in the deed records of the county where the property is located. It has to specifically state that the transfer will occur at the grantor's death. Both of them have to meet state and local deed requirements, and no payment is required by either one of them. Another major difference between the two deeds is a Lady Bird deed can be created by your agent with a power of attorney, provided that the power of attorney gives your agent that kind of authority. A transfer on death deed cannot be signed by an agent on a power of attorney. It can only be signed by mom or by the person who is the grantor of the property. That means the grantor must have capacity to sign a contract. They must understand that document, and they must have the intent to transfer that land when they pass. Another difference between the two is a warranty of title. A Lady Bird deed is a traditional deed. It's a special warranty deed or a general warranty deed. And we put the warranty language in there that says, I own this property, it's my land. And to the extent I have some sort of title policy that protects this land and my ownership, when I transfer that, my title insurance is saying, yes, I own the property. But with a transfer on death deed, if I sign a transfer on death deed, there's no warranty title. Even if the warranty of title language is in the deed, it's considered void automatically by law. If the grantee, meaning the person who's supposed to get the land when the grantor dies, if they die first, what happens? With a Lady Bird deed, it's still in place, all right? If I don't change the Lady Bird deed and I'm the grantor and I leave it to my son and he dies before me, then that will go to his heirs or to whoever his will left his property to. It will transfer into his estate, and his estate will then take over the house. If it's a TOD or a transfer on death deed, the way the statute reads is it probably lapses, meaning that it does not go on to that person. So in the TOD, you would want to name an alternative or what we would call a beneficiary that would receive their interest in case they predeceased me. Let's talk about a couple of things that are different. A deed versus a will. I get some questions about that from time to time. So a will is our general document that we use in writing to establish who gets all of our property, right? And what terms and what conditions are applicable. If I want to put restrictions in my will, I can. I name an executor who's in charge of then settling the property and paying the debts. So that's how the will works. And in my will, I can easily say, I give my house to my son who's been living with me and taking care of me for the last 10 years. I could absolutely do that in my will. But when I pass, the will has to be probated for it to be effective. Whereas a deed is specific only to the property that's being transferred inside the deed. It's not, doesn't apply to anything else. And it will transfer that property immediately without having to probate. The deed only applies to that specific property that we're transferring in the deed, but that property will transfer outside of probate. And to the extent we're using Medicaid, we have to have one. Deed versus a trust, very similar, right? A trust is certainly more customizable, and it does avoid probate. So if I have my house in a trust, it will avoid probate, and it will be very customizable and very flexible, and it'll be straightforward process when I die. However, it does not by itself avoid MERP. If that, it will, it will avoid MERP, but there's some provisions that say when I apply for Medicaid, the house will be won't be an exempt asset if it's in the name of the trust. So it'd be a two-step process. Now, it is more expensive than just simply doing a ladybird deed to the 3 children outright. But again, if we're wanting to customize it, we're concerned about how things will be administered and handled after we're gone, then it might be a better way to do things. If we have a homestead and we're not worried about a trust or a will, we're just going to do some sort of transfer our homestead when we die. There's a couple of ways to go about doing it. If we use a ladybird deed, we can transfer the house to our children when both husband and wife die, but we can reserve a right for the surviving spouse to still do whatever they want with the house, including selling it, downsizing it, moving to a different house. Now, if we don't draft it that way, then what would happen is I die and I did the ladybird deed, my 1/2 interest in the house would transfer to the kids when I die, and my wife is still alive, she would keep her 1/2 interest. Now, if we use a transfer on death deed, what we might do is say, I, husband, transfer on death to wife, the house. And then the wife would say, I, wife, transfer on death to my husband on death, the house. And so then we would name the kids as alternates or as beneficiaries. And then we would have to make sure we put some language in there that addresses what happens if one of them predeceases. A tip, when we do these deeds, whether it's a ladybird deed or a transfer on death deed, even if it's to a trust, we want to make sure that the language in the will matches the deeds. If a spouse or a parent is incompetent and we need to transfer the house to avoid MERP, or we're just doing a planning to avoid probate, then we're going to make sure we use a ladybird deed, because remember, on a ladybird deed can be transferred by an agent, whereas a transfer on death deed cannot be transferred by an agent. So it's a very important difference there. All right. That gives us a good understanding and overview of these 2 types of deeds. I could take a couple of questions if anybody wants to ask a quick question. Thanks, guys.